Illarigu namaskaralu. Those who have come from outside, it being a national conference, I have to translate it. Namaskar to you all. Honorable Mr. Justice Mohan M. Shantanagoda, the Honorable Judge, Supreme Court of India, my esteemed brother and sister judges, Sri Siddharamaiah, the Honorable Chief Minister, Government of Karnataka, Mr. T.B. Jayachandra, Honorable Minister for Law, Parliamentary Affairs, Minor Irrigation, Government of Karnataka, Mr. Kodagu Thimappa, Honorable Revenue Minister, Government of Karnataka, Mr. Subhash Chandra Kuntia, the Chief Secretary, Government of Karnataka, Mr. Kapil Mohan, Chairman, Karnataka Appellate Tribunal, and his members, chairperson and the members of various tribunals and the appellate tribunals, learned members of the bar, officers of the Government of Karnataka, distinguished guests, ladies and gentlemen, members of the media and electronic media. Good morning, everybody. At the outset, I must thank the chairman, Mr. Kapil Mohan, Karnataka Appellate Tribunal, and the organizers for having invited me to participate in the two-day national conference on the reforms in working of quasi-judicial bodies at Bengaluru. A radical change was brought about in the constitutional law by way of 42nd Amendment. Amendment was very controversial, and a lot of the amendments were to be scrapped by way of 44th Amendment, but the insertions of Articles 323A capital A and 323 capital B was inserted by the 42nd Amendment and is retained till today. Knowing fully well about the judge litigation proportion in this court, in this country, which is very poor in comparisons to any other developed countries or quasi-developed countries, the conception of establishment of administrative tribunals were thought of. The administrative tribunals were thought of because in some specialized matters, it required specialized involvement. In general sense, the tribunals are not courts of normal jurisdiction, but they have very specific and limited jurisdiction. They were established in all democratic countries in the world. The statement of object and the reasons accompanying the constitutional amendment bill by which Articles 323 capital A and 323 capital B were sought to be inserted in the Constitution was to set up the tribunals to reduce the workload of the courts, to expedite decisions, and to provide a forum which would consist of both law-knowing persons and experts in the field, falling within the jurisdiction of the tribunal. The 42nd Amendment of 1976 brought about a massive change in the adjudication of disputes in the country as provided in those enactments. The Parliament provides for establishment of tribunals to adjudicate on the matters specified in the subclauses with regard to which the respective legislatures had the powers to make rules. That is 323 capital A, power vested with the central government, 323 capital B, power vested with the state government. The 323 capital A was to be effective only if the Parliament implemented a law in this regard and the Administrative Tribunal Act 1985 was enacted. And there are also various other appellate tribunals at the central level, and Income Tax Appellate Tribunal, Debt Recovery Tribunal, Custom and Excise Service Tribunal, Compensations Tribunal, Competition Tribunal, and so on. Now, the most important amendment that was brought to by the 42nd Amendment, even prior to the date of the enactment of the Constitution, as Article 136 provided for the term of tribunal, and further there were tribunals established under the Industrial Disputes Act 1947 and under the Life Insurance Corporation Act 1956. Therefore, it is not that by the 42nd Amendment for the first time tribunals were introduced. There were other tribunals, of course, functioning within their limited jurisdiction. In our Constitution, the expression tribunal has not been defined. But the related legislations, we have some indications, and finally, in the decision of the Supreme Court of India, in the case of Durga Shankar Mehta, reported in EIR 1954, Supreme Court 520. I quote, the expression tribunal as used in Article 136 does not mean the same thing as court, but includes within its ambit all adjudicating bodies, provided they are constituted by the state and are invested with the judicial as distinguished from the administrative or executive functions. What is good for these tribunals, they are not to follow any uniform procedure. They are entitled to develop their own procedures, keeping in view the principles of natural justice and fair play. The present day situation, the tribunals are overcrowded. It shows that the tribunals, the system of introduction of the tribunal is successful. They are not judicially in true sense of term, but yet they seek to achieve the same objective as that of the courts, that is to deliver justice. That apart, even the tribunals play a very important role in dispensation of speedy justice. The tribunals have been increasing in numbers, and after the insertion of Articles 323 capital A and 323 capital B, numbers of tribunals have gone up. A quasi-judicial body is an entity such as an arbitrator or tribunal board, generally of a public administrative agency which has powers and procedures resembling those of a court of law or judge, and which is obliged to objectively determine facts and draw conclusions from them so as to provide the basis of an official action. Such actions are able to remedy a situation or impose legal penalties and may affect the legal rights, duties, and privileges of specified parties. Ladies and gentlemen, within the four walls of judicial review, tribunals carry a great responsibility of not only resolving dispute but also exhibiting higher standards of performance, as mostly the tribunals have been reviewing or overseeing appeals from the actions of the administration. The effectiveness of the tribunals can be gauged, and in fact, the very objective of setting up the tribunals can be said to be fulfilled only when the tribunals come up to the expectations of the stakeholders. And if the litmus test in that whether the institution is maintaining consistency of it being fair and judicious, apart from rendering speedy justice, I think tribunals have passed with distinction. Working of an institution depends upon the reputation which it builds upon over a period of time and lived up to the expectation of the litigating public. I am sure the technical sessions in these 2 days will be enlightening and extremely helpful to participants and deliberations, and will be able to stimulate the thought process in your minds. I am looking for a new and innovative ideas out of your stimulated and ignite minds. With these words, I wish all the best on this occasion. I am confident that the deliberations will certainly address the issues concerning the academic and policy gaps which focused attention on the role of tribunals and the appellate tribunals in perceiving the rule of law and providing affordable and quick access to justice to litigants across India, and shall continue to serve nation and the people of this great country as an instrument of government in much better way. Before I stop, I point out little aberrations. Please pardon me. The reason is there are tribunals constituted. Kindly introspect how many tribunals are full. Most of the tribunals are running with half strength. Appointments are delayed. Here, an appointment was recommended a couple of months back. I was a member of the recommending committee. The former Chief Secretary, Mr. Jadhav, is there. He may be remembering. But till then, the appointment has not come. Once the selection is made, and unless the selection is rejected for some reasons to be recorded, these selections must come as quickly as possible. Otherwise, what happens? People loses interest when they go back court, knowing that the court is not there, therefore the adjournment is as a matter of course. I call upon the administration to look into the matter seriously. I thank you all for your patient hearing and giving me an opportunity to speak on this occasion. I wish the conference a grand success. Illeregu namaskaraಗಳು. Thank you to everyone.